Hey, it's Terry Gorry, and this is the Irish Law and Small Business podcast. So I came across a case there this morning called Mr. X versus Google. It's an interesting case because of the written judgment. So I read through the written judgment. I found it interesting because the case involves a man, Mr. X, who wants to bring or has brought High Court action against Google for what he describes as defamatory material online in the Google search results about this man. And he's claiming that there is distressing material about him online on Google, and he's claiming that he has a right to seek a delisting or be forgotten by Google. The unusual thing about the case, however, is that it's actually going on since 2015. So he's complaining to Google since 2015. Now, this particular application in the High Court, and the one that is the subject of the decision to which I was reading this morning and to which I'm referring now, is an application by Google to have the court strike out Mr. X's action against Google. There's nothing unusual about that. But Mr. Justice Max Barrett, in looking at the case and in deciding the case, recognised that Mr. X is a lay litigant. He's representing himself. Google has a very big firm of solicitors on their side, A&L Goodbody. But it transpires then that Mr. X is a man of a certain age and is not that sophisticated or comfortable using a computer. And the bottom line is, Google's position is that his claim should be struck out. And it should be struck out on the basis that he's failed to prosecute his claim within time. In other words, it's going on for 5 or 6 years, and he has 12 months within which to sue for defamation. But there's two principal arguments being put forward by A&L Goodbody and or Google as to why his case should be struck out. And one is that he has failed to submit the precise URLs of the offensive material. And Mr. X has told the judge that he hasn't done this, he's unable to do this, he's not the best with the computer, he's not that sophisticated, and his age is not clear from the decision. But the judge has formed the view that he's certainly an older person, an older gentleman. So he's making an argument that he's not that sophisticated and not that familiar with computers, etc. But the judge is actually making the point, or seems to have arrived at the point, that he says that there's no legal authority for Google insisting upon the precise URLs. In other words, this man is claiming that there's defamatory material published by Google, and there's no legal authority for the proposition that he must submit the precise URLs of offensive material. The second interesting point in the case itself, in the hearing itself, is to do with A&L Goodbody's argument from their solicitor in an affidavit that Mr. X had failed to use the online complaint form. There's an online complaint form where you can stick in the offending URL or URLs and ask Google to deal with it. It's not called a complaint form, it is some sort of a submission. But you know yourself, Google and the boxes and submitting a complaint, etc., it will involve some sort of an electronic online submission. And again, Mr. X has failed to do this, again because he is not that familiar with and is not conversant with computers. However, the judge has again found or commented that there's no legal proposition or no legal authority for the proposition that you must submit through Google's search form or Google's online complaint box. So they're the two interesting points that I saw in the decision itself. However, as I read through it, I got down to the end of it, and at the end of the decision then, there is, and I've seen this before from this particular judge, the judge is Mr. Justice Max Barrett, and at the end of this judgment, and the judgment is it's actually 16 pages long, but at the end of it, and I want to read this because it'll give you an idea, and I think it's a great idea, it'll give you a flavour of what Mr. Justice Max Barrett does, but at the end of it, there's 2 pages entitled Plain English Note. It says, "Dear Mr. X, dear Google, I've just written a detailed judgment about the application brought by Google regarding Mr. X's case. The judgment contains a lot of legal language which can be hard, even boring, to read. In a bid to make my judgments easier to understand by those who receive them, I often now attach a note in plain English, briefly summarising what I have decided. Because Mr. X is self-represented, I thought it might assist for me to add such a note in this case. This note is a part of my judgment. However, it does not replace the text in the rest of my judgment. In a bid to ensure that people do not know who Mr. X is, I have not used his real name in my judgment. This may seem a bit artificial. However, I think it is for the best. Mr. X's pleadings in this case are, with respect, inadequate. At their most basic, pleadings need to demonstrate a recognised cause of action and the necessary elements of that cause of action. Putting matters at their most elementary, by reading Mr. X's pleadings, Google cannot tell exactly what case is being made against it and what defence and what arguments it might usefully make were this case to continue to trial. Judges, however, have traditionally declined to strike out proceedings where it's possible that an amendment to pleadings might remedy whatever deficiencies have been identified. I consider that there's enough in what is before me for the first or for the most just course of action to be that I stay these proceedings for 6 weeks, so as to give Mr. X time to amend his pleadings as he sees fit, and then bring application for any amendments that he might propose to be allowed. Though I cannot oblige Mr. X to retain legal advisers, I respectfully do not believe that these proceedings will go much further without the involvement of legal advisers. Mr. X should note that 1. Any application that he might make to amend his pleadings may or may not succeed. 2. I'm not recommending or directing, it's not for me to recommend or direct, that he should engage legal advisers. 3. This judgment and any, if any, future judgment allowing him to amend his pleadings should not be treated by him as an indication that he will necessarily be successful in the case that he wishes to bring. Mr. X and Google may assume that if the pleadings remain as is, or any application to amend the pleadings is unsuccessful, I will strike out the claim earlier, 1 in 6 weeks, either in 6 weeks' time, or 2 after any application to amend that is heard around that time proves unsuccessful, if it proves unsuccessful, whichever is later. In the unlikely event that there is a conflict between the text of this letter and the text of the main body of my judgment, the text of the main body of my judgment shall prevail. Yours sincerely, Max Barrett, Judge in brackets, date 8th February 2023. I think that's excellent. It's a 2-page explanation in plain English from the judge to both Google, who don't need it, but to Mr. X, who clearly needs it, setting out precisely what the position is, what he has decided. So there's a 16-page judgment which refers to the rules of court, the law, previously decided decisions, and then there's this 2-page plain English note telling Mr. X that he needs to reconstitute his pleadings if this thing is to go anywhere. He's recommending, or not so much recommending, but saying that he needs the assistance of legal professionals in order to redraft his claim, his proceedings, and if that's the case, he may or he may not be successful. This plain English note procedure or practice by Mr. Justice Max Barrett, I think, is an excellent one, especially obviously in circumstances where the plaintiff or claimant is self-representing and is a lay litigant without the benefit of legal expertise or training or so on. So it's an interesting case. It's Mr. X versus Google. Mr. X says that there is material about him online that is defamatory essentially, but it's not clear what exactly is called the distressing material online. Mr. X has been engaging with Google for 6, 7, 8 years now at this stage, since 2015 I think, and obviously there's a procedural issue there because it may well be that he's out of time to bring a claim for defamation, etc., etc. However, the judge hasn't done that. It's given him a further 6 weeks, but more importantly, the judge has given a plain English note at the end, making quite clear to Mr. X where he stands and where he should really go, marking his card. I think is a good practice to adopt. I'm not saying judges should do it in every case, but clearly if there's a lay litigant involved, it's very useful. Anyway, I might stick a link to that. Let me see now. Yeah, look, it's a case called, it's a High Court case. It's the citation on it at the moment is 2023 IEHC 56, and the original proceedings commenced in, I think, 2020, and the case number is 2020 1480P. Hope you find this video useful. If you do, I'd appreciate if you gave it the thumbs up down below, and you may be interested in subscribing to my YouTube channel. If you are, just hit the subscribe button below the video and hit the bell icon, and you'll be notified every time I publish a new video. Thanks a lot.